Thank you very much, Mr Chair. Just to follow on from my colleague Chris Farfoy, it's quite clear that obviously Part 2 of this bill goes through in significant detail the procedure for the granting of legal aid and the cases for which it can be granted. Most of what is in here is of a relatively technical and non-controversial nature, but there are several points, Mr Chair, that I do want to refer to, and one of them is in some senses, I think perhaps something that a number of people perhaps don't realise about the legal aid system, and that is around both the potential withdrawal of legal aid and also the repayment of legal aid. Because as my colleague David Parker said before, in fact legal aid is generally, although not always, effectively granted as a loan, and the repayment of that loan and the procedures around how that might happen are outlined in Part 2 of this bill. But in particular, there is the ability for the Commissioner to withdraw legal aid from an aided person. And I do think it's important that people are aware that that capacity exists. And I'm looking here at Part 2, Clause 29, where the Commissioner can withdraw legal aid if they're satisfied that the aided person has sufficient means to enable the person to obtain legal assistance and representation. And I think that goes to the concerns that my colleague David Parker raised earlier about is everybody getting this, is it appropriate? And as I said when I made my contribution, I slightly differ from my colleague because I think that the default position we should be in here is that everybody has equitable access to justice. And as Chris Farfoy has just said, there are people who are struggling to make ends meet, having difficulty with the rising cost of living and increases in GST and all those sorts of things. They need to know that there is a basis for them to have access to justice. But there has to be a limit to that, and I think we all respect that the sums of money that have been discussed already, the $400 million hole in the funding of legal aid, we obviously recognise that there are some limits to this. So Clause 29 actually goes into that and specifically notes that the Commissioner can withdraw that aid if they believe the person receiving it has sufficient means. They also, that the Commissioner can do that if they consider that the interests of justice no longer require legal aid to be given to that person. Now that's a weighty task. It's important that it's undertaken sympathetically. One person's belief about whether justice is required any longer can be quite different from another's. So they are important elements to this bill that are within the bill. And I think sometimes we get people believing that legal aid is this bottomless pit to which people can simply go on and on and on, as Chris Farfoy notes, taking on, sucking money from the taxpayer pool. But in reality, in this bill, in this part of this bill, we have actually a mechanism by which that can be managed and controlled. So I believe, in fact, that this provides the integrity to the system, the balance of my earlier contribution, Mr Chair, where I do believe that people of insufficient means need to know they have access to justice. The balance is here that if in any way they are not perhaps legitimate in that desire or that requirement, then there is a mechanism to deal with that. And Clause 30 does the same thing in terms of civil matters. I want to turn now, Mr Chair, to the question of community law centres, and I think on this side of the House we are particularly pleased to note that this bill starts to give some certainty around the survival and the funding of community law centres. And I actually do want to acknowledge here Mr Powers, the Minister's contribution earlier about setting this bill in the context of a wider package. And I do think that the notion that community law centres will play a part in that, an expanded public defence service will play a part in that, and the way in which we're making changes to legal aid here in Part 2 will play a part. I think it is important that we do understand that that is the breadth of the package. We're obviously, on this side of the House, great supporters of the Public Defender Service brought in under the previous government, and pleased to hear that it will be expanded. But also, this is, and my colleague Jacinda Ardern asks, why not Palmerston North? There are a number of places that it could be expanded to, and I think
good time.
I think it's important. So that's where he's going. So it is important that we do find this whole package together. But on the subject of community law centres, I think every MP, particularly electorate MPs, will know of the value of community law centres. Those of us who get a lot of cases involving issues like immigration in particular, but also more bread and butter issues around people's tenancy rights, family and custody disputes, know the value of the community law centres, knowing as an MP that you can refer somebody there and they can get the response they need is just so crucial, Mr Chair.
Called Kawaljit Singh.
Mr Chair, let me start